Guests, a very warm welcome to all of you. We have the honor of having with us today morning Honorable Shri Justice Uday Lalit, former Chief Justice of India. May I request all of you to kindly welcome, sir. I request Professor Sudarshan to please accompany sir to the dais. I request Professor Sudarshan to kindly welcome sir.
It's a real pleasure to have Justice Lalit here with us today. It's a very hard job introducing someone who everybody knows about. So I will give that very hard job to my colleague Professor Narayanan, who is the head of CPS. Instead, I will do the opposite job. We spent the last hour or so introducing IIT to him. Okay, so we've already done that, but let me just summarize what we told him for the rest of the audience here. You may wonder, we had an Indian Institute of Technology, and how come the retired Chief Justice of the Supreme Court is here? And there are many reasons. The first, of course, is that he is really interested in connecting with our students, and he would like to actually teach a course. But then the question becomes, we don't have law students here, so what is the connection? And there are very interesting connections. The most immediate and direct connection is that law and policy are very tightly connected, and we have the Center for Policy Studies, which was formed about 7 years back, and which is doing very well. They have, I think, 60 PhD students, about 8 faculty, and it's growing. So this will be a great fillip to that center. But even going beyond the center, technology today pervades everything, including law. And for us, it is a great opportunity that he is interested and will be working with us as a distinguished visiting professor. The goal is to have periodic visits, maybe weekly or for some months in a year, where he will be actually teaching our students. So we look forward to very fruitful cooperation, and we are really honored that somebody of his stature is actually interested in coming and doing this here, and we are sure that it will lead to some very good results. So with that, again, I would like to welcome Justice Lalit, and I will call upon Professor Narayanan to give a more detailed introduction. Thank you.
Thank you, Professor Sudarshan. It's a very proud moment for the Ashang Desai Center for Policy Studies, IIT Bombay, when Honorable Justice Uday Umesh Lalit, the former Chief Justice of India, is joining us as a distinguished visiting professor. At the outset, on behalf of the entire faculty, students, and staff of ADCPS, let me welcome Justice Lalit as Professor Lalit to IIT Bombay. The Center for Policy Studies is relatively a new academic unit that started in 2016 that later received a generous financial support from our distinguished alumnus, Mr. Ashang Desai. It had a fast growth trajectory with currently 8 core, 3 adjunct, and 22 associate faculty members. Professor Lalit is our first distinguished visiting professor, and Dr. Mihir Shah, a former member of the National Planning Commission, will join us soon. ADCPS has 62 PhD students and a Master of Public Policy program. Although Professor Lalit needs no introduction as my duty, let me give a brief background about him. He was born in Solapur to a family of lawyers and graduated from the Government Law College, Mumbai. Enrolled as an advocate with the Bar Council of Maharashtra and Goa in 1983, he started his practice in the High Court of Bombay under senior lawyer M.A. Rane, who was a proponent of the humanist school of thought. He set up his independent practice in Delhi in 1986 after working with eminent lawyers like P.H. Parekh and later with the former Attorney General of India, Soli Sorabji. He was designated as senior advocate by the Supreme Court in April 2004 and appeared as amicus curiae in many cases related to environment and forests, vehicular pollution, and pollution of the Yamuna River. He served as the special public prosecutor for CBI to conduct trial in the 2G scam under the orders of the Supreme Court, and also served as the member of Supreme Court Legal Services Committee for 2 terms. Within a decade of his appointment as senior advocate of the Supreme Court, he was appointed Judge of the Supreme Court of India in August 2014, the second CJI to be directly elevated to the Supreme Court bench from the bar. During his tenure as a judge, he has been part of several path-breaking verdicts, including triple talaq and the POSCO verdicts. He has served as the executive chairperson and later patron-in-chief of the National Legal Services Authority and worked to facilitate access to legal aid for under trials. Justice Lalit brought in several reforms to the workings of the Supreme Court, including advancing court proceedings to 9 a.m. from the usual 10:30 a.m. He was appointed as the 49th Chief Justice of India in August 2022 and retired in November 2022. We in ADCPS, on behalf of IIT Bombay, would like to again welcome you as Professor Lalit. Now the floor is yours, sir.
All the distinguished members of the faculty who are present here, the students community, everybody who is present here, ladies and gentlemen. I have spent something like 40 years in the field of law. Initially as a lawyer, the first innings, the second innings as a judge. After my retirement, I wish to start the third inning, perhaps as a teacher or a professor. Now, the obvious course or the choice would be the law subjects. So I have been associated with some of the law schools or the universities to teach the programs in law. But an invitation came that whether will I be associated with Center of Policy Studies here at IIT Mumbai. My initial reaction was, I hardly know anything about engineering or technological subjects, which are the very basis of every program which is conducted at the IIT. But to my pleasant surprise, I was told that it's not strictly based on engineering or technology. It has something interface with some other fields as well. And they said that with my experience, I don't call it very rich experience, but very lengthy experience of at least 40 years, I may bring to bear some facets or some nuances of law, and then perhaps I think the course can be very, very significantly get enriched as a result of that. I don't know whether my association will ultimately achieve that goal or not, but perhaps I think this invitation sounded very, very encouraging, and therefore here I am before you. Before we start our regular courses, I said let me address at least on a topic which perhaps may be of some interest to budding engineers or graduating engineers. Most of you who will hereafter, you're the cream of the society who is here at the IIT, will either be donning the mantle and managerial capacity or in administrative capacity, taking certain decisions on behalf of your organizations, whether they are in public sector or they are in private sector. But in your managerial capacity, whatever decisions you take, perhaps I think those decisions must be consistent with the process of law and the principles of law. And therefore, I thought that perhaps one topic which could be of some interest to the budding graduating engineers would be administrative law. And therefore, I chose this topic just as an initial ice-breaking kind of mechanism to let us see whether, the waters that I want to swim, whether I can test those waters to be deep enough for me to swim here. Administrative law is, what do we mean by administrative law? We have in our political structure adopted a system where there is a legislature which is directly elected by the electors. There is an executive which is answerable to the legislature. And there is a judicial organ which tries to keep everything in check. But who administers the policies, who executes the decisions which are taken on the floor of the House in the form of enactments? It is the administration, the executive. Now, what kind of internal mechanism or policy or principles these executive decisions must be in conformity with and bound by are set of rules which in normal parlance what we call as administrative law principles. So in theory, what does administrative law mean? It is the code of conduct or the principles or the parameters with which the administration must conduct itself, and every action of the administration must be in conformity with these principles so that the objective which the administration is supposed to achieve is attained, number one. There are least areas of friction, number two, and there are no challenges hereafter so far as the administrative actions are concerned. Now, theoretically, in our political structure, what we have is what we call the grand norm or the basic document is our constitution. That is our Constitution of India, which has certain principles and which are inviolable principles. So therefore, we say that this is something the document must be binding on every single action of the government or the organizational structure. Very well. So at the top or at the top level is the Constitution. Then follow what is called the legislative instruments. Your parliament or the house in the legislature in the state, they are competent to enact laws. So the laws enacted by the state legislature or by the parliament, or what we call the enacted principles of law, will be the second category, which is just below the Constitution. The third category, every single provision need not be part of the enacted statute, because your elected representatives who enact laws on the floor of the House perhaps may not have contemplated every single provision or every single contemplated situation of circumstances. So there has to be some leeway, there has to be some area for the executive or the administrators to operate. And therefore, what we have thereafter, after the enacted law, is what we call the statutory rules. So the statutory rules are enacted by the executive, but with the concurrence, that is to say that the rules are tabled before the House, so tacit concurrence by the House. So these are normally called the statutory rules. Even statutory rules may not have contemplated every single possible situation of various circumstances. So therefore, what we then thereafter have are the executive decisions, which are the policy decisions or executive decisions to implement in a given set of circumstances. So policy could be general, or executive decisions could be specific, fact-specific. Now, in administrative law, what we have is the principle which is called ultra vires. That your executive actions must be in conformity with 1, 2, 3, that is the Constitution, enacted law, and the rules which are the statutory rules. Your statutory rules must be completely in conformity with the enacted law and the Constitution. And of course, the constitutional principle is that your enacted law must also be in conformity with the constitutional principles. So this kind of hierarchy which we maintain in order to test whether the decisions are correct, binding in law, and should be implemented or not, they are founded on the principle of what is called intra-vires theory. Every action of the concerned individual or the executive action must be in conformity with what? The Constitution. Number 2, the enacted law. Number 3, the statutory rules, and everything else governing the field. So what do we have? Action of the executive must be in conformity with the settled principles of law. So the first binding nature or the filter with which we will consider and judge every administrative action is that it must be in conformity with the settled principles of law. Very well. The second, it must attain the objective of the enacted law for the purpose for which it has been put in place. I'll give an example. There is an enactment called Illegal Migrant Determination Act. Now, those who illegally enter the country, their status is to be determined. If they are illegal migrants, they may be deported. So who looks into that? Now, this is of course the legislative policy or the principle that yes, every person who has entered the shores of this country illegally must be identified and must be relocated or deported. So who looks into that? Now, this is called the policy implementation. So first and foremost, for the purposes of determining, you must determine the status of that individual. Whether that individual is a citizen of this country or not a citizen of this country. Who determines that? So the persons who are given the charge of implementing this policy will have that status, will have that authority to determine this question. Very well. So what must they determine? They must determine in consistence with the principles of law. Supposing if there is a cut-off date, you must determine apropos that cut-off date. So the determination has to be consistent with the law or with the policy which has been enacted by the superior legislature. That is either the Constitution or the enacted law and everything else. Now, one basic principle. If you are determining something which may go against the interest of an individual or a citizen, should you not hear him or her first? So one classic principle of administrative law which is always accepted is that no man can be condemned without being heard. So if you are determining the status of an individual, you must give him adequate notice, number 1. You must give him adequate opportunity, number 2, to dispel that impression. It is only after that process is gone into that you will be able to determine the status of that man. So one classic principle of administrative law is that no person can be condemned without being heard. Now, for instance, let us go into another example. You must have seen in and around Mumbai, there are so many slums here. Now, there is a policy, which is the enacted policy, that very well those who are slum dwellers and who are sitting there for a fairly long time, there is a cut-off date. That after that date, if persons are sitting there, even prior in point of time, they must be given some kind of regular accommodation of at least about, say, 300 square feet free of charge at the place itself. That's a policy. That policy will naturally entail some kind of incurring of expenditure. Now, expenditure can never be incurred limitlessly by the executive. So therefore, they have devised a policy that very well, let us invite proposals from the builders or the developers. Part of it, because the slums will always be at the horizontal level, so they may occupy a large piece of land, but the number of slum dwellers may be comparatively less. So the development is horizontal. Instead of that, let us have a vertical development where there are apartments which go right up to 20 stories or 25 stories. So a builder or a developer will have two components, one what is called rehab component, where he rehabilitates all the slum dwellers. The second component is a sale component, where he sells certain apartments at that place, and from the income which is generated from the resources, he builds the rehab component. So the state is not making any expenditure. The development actually spends for itself or takes care of itself in the form of slum dwellers getting good accommodation. And that's a very humanitarian angle which has to be brought to bear to the entire development. Naturally, another question. Who are those slum dwellers who are entitled? In order to locate those persons. So therefore, at the policy or the grassroots level, what we normally contemplate is the determination of a status of an individual, whether he or she is entitled to the benefit under that legislation or the enactment, or is he or is she supposed to be on the wrong side of that. So the determination of that man. So most of the litigation on the administrative law side is on the determination of the rights of that particular individual. And most of the litigation with which we come across as lawyers and judges are the nuances where either that person or an individual is not given a proper hearing or is not allowed to give the documentation in support of his or her claim. So therefore, the various shades of challenges which come before us are dealing with that. What is the message or the principle that we deduct from that? First and foremost, those who are supposed to be implementing the policy must be very, very fair, transparent when it comes to locating the individuals concerned who are supposed to be the beneficiaries of that policy. Now, for instance, another example. There are certain states where they give scholarship to girl students who go beyond the level of 10 and 12. Again, in order to identify who are entitled, because most of the bungling actually happens at that level. In order to identify who are the persons who are supposedly the beneficiaries of that particular policy. So this was one area which I said. The second principle of administrative law, which is again considered to be very, very fundamental, is the principle that no person should be judged in his own cause. That is, if I am determining something where I am interested, I should not be sitting in that chair as an adjudicator or a judge. So therefore, there must be completely unbiased, impartial, and completely equal kind of dispensation which must be brought to bear to the entire controversy. So the person must be completely disinterested. He must have only one idea, and that is carrying out the objective, which is the legal objective. Nothing this side, nothing that side. So that independence and impartial, these are two fundamental principles of administrative law. And mind you, my experience shows that every challenge, undoubtedly, 80% of the challenges pertain to these two areas. Now, as engineering students, you will be taking certain policy decisions. What should be the guiding features or the factors which must consider, or which must be at the thrust of everything when your decisions are taken? Number one, you must be aware of these two principles. Whatever you do it with giving adequate notice, opportunity to the person concerned whose interest may be adversely affected as a result of your decision. Number two, you must have that complete impartial attitude to the entire circumstances to be considered. Now, I'll give you one or two examples where the challenges come, because we learn from the experience when the matter reaches the court. When the matters reach the court, that's when we learn, yes, very well, this is the mistake which has been committed. Motilal Padampat is one very beautiful case. What happened is, in a particular state, an incentive scheme was adopted by the state government to see that there is tremendous amount of investment in infrastructure. Certain units come up in that level, which will in turn generate employment, and which may in turn generate some kind of revenues in the form of sales tax, octroys, etc. So therefore, the coffers of the state will also get enriched. At the same time, because of investment in, say, various projects, employment will also get generated. In order to attract the investment, they came out with a scheme saying that any company or any entrepreneur who establishes a unit of manufacture in this particular state will have sales tax holiday for 10 years. That is to say, for 10 years, the unit need not pay any sales tax on whatever are the manufactured items which are sold in open market. Now, this is an incentive scheme on the basis of which the entrepreneurs were invited to make the investment in the state. A unit made the appropriate investment. In the third year, the scheme was withdrawn. Now, the unit came up before the court saying, look here, we were led up the garden path. We had certain difficulties. Our manufactured sort of inputs had to be carried from one state to the other. That involved tremendous amount of expenses on transportation, manpower relocation. We did that calculations. Why? Because we thought that perhaps 10 years sales tax holiday will be a sufficient incentive for us to invest in that particular state. And now that you have taken that carpet from under our feet, we don't have sales tax holiday. We have made tremendous expenditure so far as relocation of the factory unit is concerned. So we are worse off on both counts. Now the law was developed by the Supreme Court in this fashion that if an executive has made an invitation on the basis of which somebody makes or changes his position to his detriment, then the executive must be held bound by the promise that it made. So therefore, in effect, whatever be your new policy where under you don't want to give this incentive, if a person or a unit has set up its manufacturing facility in your state, then regardless of change in your policy, that unit must continue to avail the advantages under your old policy of incentive. This is what we call in law promissory estoppel. So once you have given a promise, you are estopped from taking a different position. Now these are nuances of administrative law. What does that mean? That you have, as a result of policy, invited somebody to change the position to his detriment because he believed in that policy. He believed in that promise. And the moment he changes his position, you can't leave that unit high in the lurch completely. So therefore, allow everything what you had promised. Now this is one principle which has developed in administrative law. Why? Because you can't be doing something which is completely whimsical. It has to be consistent with an idea that it goes with the original idea of your policy. Does that mean that you can't change your policy? You can. For prospective investment, certainly yes. But those who had made the investment already, they will still be governed by the old policy. If you consider that, look here, I have got now sufficient investment. I don't want further or future investments in my state. Then you can certainly have that policy whereby no new person will be now invited or encouraged to join and set up unit in your state. So therefore, change is permissible, but change is permissible which is prospective in nature, which will not affect whatever was done earlier. That is to say that the change will not be retrospective. Why did I give this example? This is only to say that as persons who are framing a policy, when you are framing that new policy, you must also see what was the existing situation. What was the existing situation under which certain people had taken a different stand, had changed their position? If that be so, then I should not touch those persons adversely. So therefore, as a person who is implementing or framing a policy, you must not only be concerned with, number one, the objectives of the enacted law, but also the real-time situation which is there, a ground situation. So therefore, if there be some kind of change which has already undertaken and occurred, that change should not be completely displaced. So therefore, you must also be consistent with your old-time policies and they must also be carried forward. Now, this is the obligation which comes on a policy framer. Now, one or two areas where normally we as law professionals grapple with the challenges when it comes to administrative law decisions. Various times, various occasions, what happens is, see, I must tell you, road building contract, investments, power projects, any kind of, the technological innovations have at the base what we call the engineering and technology. The sum and substance of that. Now, for instance, if you want to have something like, say, Worli Sea Link, and you are inviting tenders, what will be the law professional be dealing with? He doesn't have that kind of wherewithal or the basic idea whether that Worli Sea Link is feasible or not. That is your engineering, correct? That is your technological facet to the matter. You must be satisfied, number one, on the technological or engineering front that such a thing is possible. If such a thing is possible, feasible, and something to be encouraged, so the decision to do that is completely technologically based or technologically driven. When you are trying to implement that decision, in order to see that there is complete equal treatment, then what you must do is, very well, I advertise it so that everyone who is supposed to be interested in coming over and having that kind of project is given adequate notice and invitation. It is that part which the lawyer will certainly look into and say that whether there was adequate notice, whether there was adequate invitation or not. So as a lawyer, we are not concerned with whether that Worli sea link is feasible, possible, or advantageous or not. These are normally called Swiss rule ideas, where innovation comes for the first time, where somebody comes for the first time with an idea that very well, I'll build something, I'll cut across a bridge from Gateway of India to Alibag and then reduce the entire distance. So he is the innovator of the idea. So these are normally called Swiss rule ideas, which come for the first time from the innovator. A road to be built connecting Mumbai and Pune, what is called is the repetitive action. So therefore, in such matters, the tenders will certainly have a different idea and complexion. But leave aside that. For the lawyer, we deal with, lawyer and judges, we deal with only the second part, which is whether somebody has been given adequate notice and opportunity or not. That is why I said the first principle, you can't condemn people without being heard. So the notice, adequate opportunity happens to be the cardinal principle of everything. And that leads us to one more principle in administrative law, which has been developed by the Supreme Court over a period of time, and which culminated in a decision called Tata Cellular, that we are not concerned with what is called the decision itself. We are concerned with the decision-making process. Whether there should be something like Worli sea link or not, we are not concerned as judges. That is for the technological front. That is the idea which the person concerned or the state concerned must entertain, accept, and then go ahead with. We are only concerned with the decision-making process, that while arriving at such decisions, whether you have taken adequate sort of components into account or not, whether the material that you have taken into account is adequate and relevant or not, or whether have you taken into account relevant material which is completely irrelevant. So therefore, we are not concerned with that. So the administrative law is not concerned with your decisions. The administrative law is concerned with the decision-making process. You just want to see whether your process is something which is in the right direction or not. These are some of the ideas with which we go ahead in administrative law. Finally, what? What are we trying to achieve out of this? Number one, the executive or the administration must be given freedom of choice in the area where it wants to operate. But given the choice and the freedom in the area where it wishes to operate, it must act in conformity with some basic ideas and principles. That is, its approach to the entire controversy must be absolutely fair and transparent. Its approach must subserve the original enacted law and the ideas emanating from that enacted law. Number three, it must be completely impartial. It must not have any private agenda to achieve. Private agenda at times is you have already selected a man. You have already selected an entity which is supposed to be given a tender. You just come out with what is called a show, have the invitation. The man is already selected, you know what it is to be done. The second stage of that is that you develop parameters which are ideally suited only to select this person. So therefore what you start doing is, if my project requires say ABC as components, and I should be good enough with ABC, I add D, E and F as well. So that D, E and F can be satisfied only with that blue-eyed boy and not others. And then projecting as if my technological idea requires A, B, C plus D, E, F, and therefore he or that particular entity alone is now the surviving competitor in the scene. So therefore he or she gets selected. So one normal challenges with which we come across on the administrative law side is what is called rules of game getting changed to suit a particular objective. Where does it lead us? It leads us again to the second principle which I said, that no person shall be judged in his own cause. You are not being impartial to the entire matter. You are not trying to get the best possible person in the bargain. You are not trying to get the best possible idea. What you are trying to do is, you have a man in mind, you are actually suiting everything, tailor-made kind of, conditions. Now that's the area where the courts will again intervene and say whether DEF is actually contemplated or not, whether is it required or not. To a certain extent, the courts have gone into that. Why? In order to eliminate this kind of completely partial attitude which has been brought to bear by the authorities concerned. For our purposes today, we must have only 3 or 4 principles as persons who are going to frame policies hereafter. Number 1, you must be completely fair and transparent. Number 2, you must be guided by whatever is the object which is supposed to be achieved. Number 3, you must be completely fair and give equal treatment to everyone, have that impartial attitude which must be prevalent all through. And number 4, no person should be condemned without being heard. If you have these 4 principles which are at the back of your mind every time, then whatever you frame will be a policy which will stand the test of time and the scrutiny by every court. Today you are budding engineers, graduating engineers. Some of you may enter the management courses. Some of you may enter the civil services. Whatever you do in your managerial capacity, you will be called upon either to frame a policy or implement a policy which has already been framed to a certain extent. And while discharging your duties, if you have these 4 principles which are close to your heart, then mind you, my sincere advice is, if you keep these 4 principles close to your heart, you will never falter in life. Thank you so much. Thank you.
Thank you very much, sir. May I request Professor Rao and Professor Sudarshan to kindly join us on the stage to present a bouquet and memento to sir. Professor Rao, kindly come. Ma'am, may I please request you to kindly join us on the stage. Thank you. Sir will answer a few questions. I request Professor Narayanan to join us on the stage. Yeah. Okay, thank you.
I must tell you, this is my first visit to the IIT. I have gone by the road where the gate begins here, but never entered the premises. I had never seen the budding engineers, except for the fact that my younger one is also a graduate from IIT, so I had only gone for his convocation. But it's a pleasure being here. It's a pleasure seeing the sparkle in the eyes of youngsters. And perhaps even when I was talking on a subject which is slightly not part of your curriculum, something which is completely outside that, but the interest was certainly there on the faces of all these young students. Thank you so much. So I am here now to answer any question. In case you have any, please shoot.
Hello.
Yes, sir.
Yes, sir. My name is Govind Maurya. I am PhD student here in Energy Science department. So my question is, as you said that you are concerned with not whether decision is right or not. You are concerned with decision making process is right or not. So my concern is that the loopholes in decision making process, which seems to be that it is right, but that is not actually correct by the ethical concerns. Or you can say, suppose you consider environmental cause or social cause or any cause. So let me give you a few examples. Like in Delhi, there are many buildings which are illegal, but they have been approved by the Delhi authorities. Similarly, in Mumbai, there has been several buildings illegal, but they has been approved. They had been approved by environmental department also. So let me give one example of IIT Bombay also. So IIT Bombay is making Desai Center. So they have cut 21 trees. So BMC has asked them to plant 42 trees. What they have done, they have planted and they have been asked to have separation of around 2 meters. So what they have done, they have planted means beside the main road, in between those bigger trees whose expansion is more than 4 meters. So they have planted from that 2 meters from the root of those bigger trees. So this is not actually right kind of environmental cause, but the thing is that they have done decision making process is right. So what is your opinion? Because who will decide that decision making process is right and it is illegal or in terms of ethical sense?
See, as there must be some authority which must have initially imposed a restriction or a condition that in case you want to fell the trees, in order to have that particular center to be developed there at the site, what we call compensatory afforestation, correct? So therefore you must have equal kind of tree planted at some other place. So as a policy, nothing wrong with that. The implementation of that is something which according to you was a fractured one, correct? So according to you, rather than allowing trees to come up where they may have enough space to develop into huge trees on their own, since you have planted between two huge trees, their growth will always get stultified. So this perhaps is the idea, and therefore while doing that, the implementation was completely fractured one. This is what I understood is that. Now, here supposing in case you were to challenge this, correct? Now, what is the parameter with which the courts will bestow attention? The courts will say that very well. The first idea, imposing a condition, was a completely correct one, that the trees must be planted. The trees were planted. The only thing is that the location of the planting was not something correct. correct? So once you say that the location was not correct, such a decision, if challenged, will certainly be looked into by the courts. When I say decision and decision-making process are different, they are completely on a different plane altogether. I'll give you another example since you gave the example on the environmental front. Sometime in 2001-2, the entire bus fleet in city of Delhi was switched over to CNG, which is called petroleum natural gas or compressed natural gas, instead of diesel. Who took that decision? The decision was taken by the executive, which said that 31st of March so and so, the entire buses, the fleet of buses in Delhi will be switched over to CNG. The decision was not taken by the courts. The decision was by the executive. The court simply held the executive to be bound by that decision. Why? There's a very famous saying by Justice Frankfurter from US Supreme Court. The executive must be held bound to the policy which it professes to apply. So the executive had professed the policy that by 31st of March, the fleet will turn into CNG. Why? Because CNG is supposed to be environment-friendly fuel. Otherwise, you will have suspended particulate in the entire environment, which can be deleterious and dangerous for the human health. So the Supreme Court simply held that you are bound by that decision, so implement it. The decision was not by the Supreme Court. So here what was done was you just implement that decision. Now one of the nuances could be that when you are implementing the decision, supposing somebody says, oh, I'll go by technology A, rather than implementing, what is called retrofitting. Supposing the diesel buses which are already being plied, I will simply put a cylinder and retrofit it and those buses can be plied. Somebody may say, no, nothing doing. I will have the engine which is running purely on CNG. So right from scratch. Now the technology is not for the courts to adopt. So that is again part of decision. Which particular technology to be adopted? The courts will say, sorry, we are powerless. We don't have the kind of wherewithal to go into that. It is for you to decide. But you must adhere to that deadline. So the distinction between decision and decision-making process is slightly of a different nature. So decision-making process is that while you are arriving at the decision, you must take all the factors which are relevant for the consideration into account and eschew or eliminate all the factors which are completely irrelevant. So there are two ideas. Take all relevant factors into account, so inputs must be absolutely clear. And while taking the inputs, rule out everything which is supposed to be irrelevant. So therefore, that is what is your decision-making process. Once you have taken these kind of steps and the precautionary ideas, then the courts are not going to get into that. Correct? So that is what we say. Decision is not something the court will go into. Court will only consider the decision-making process. Okay? Thank you. Yes, ma'am.
Good afternoon.
Yes, sir.
My name is Shyama Solekar. I teach environmental engineering here at Environmental Science and Engineering Department. We have a undergraduate, master's as well as PhD program in environmental engineering, in which environmental law has been a part of curriculum. My question is about the precautionary principle and a gap that we all are finding in almost every important case, where the understanding of environmental ecosystems is really growing in exponential rate, and the abilities of technologies to fulfill the shortfall are also growing because new technologies are coming up. The real difficulty in implementing the precautionary principle is not really knowing the limits of technology, which will really be able to fulfill the or eliminate the doubts in the minds of either executive or in the legislature. It is very difficult today that we do not have enough deeper understanding of ability of technology for not leaving permanent damages to ecosystem. And the precautionary principle precisely is going after it, which is a really golden principle. And last 50 years all over the world, this particular gap is coming up. In India, we are facing far too much gap because we are not really adopting the best possible technologies. And that is where a lot of work has to be done. And really, welcome to IIT Bombay. A person like you will shine a great light on it. But how do we really see it in the context of constitution, this particular gap in India's constitution interpretation? Maybe it's a long answer, maybe it's a short answer. I'm sorry if I'm expecting.
No. You are certainly entitled to have your answer. The only thing is that this is not touching upon the administrative law. This is completely in the field of environment. But I'll give you the answer. See, as you said, precautionary principle is one cardinal principle when we are dealing with environmental issues. The other principle is polluter pays, correct? Whoever is the polluter, who pollutes the environment, must be made to pay for the damage which has been caused to the environment. One classic case of precautionary principle getting adopted, implemented under the orders of the Supreme Court is Kudremukh Iron Ore Company. Kudremukh was a public sector undertaking going into mining activities on the western coast of the country, somewhere near Mangalore, south of Mangalore. A very throbbing, thriving company. It was not as if that it was running into losses or it was bleeding the exchequer. It was a very throbbing, thriving company, yet the environmental studies actually showed that the area where it was having its mining operations, that is called Western Ghats. Western Ghats has always been considered to be one of the hotspots of biodiversity. Now, biodiversity is something which is so fundamental for the existence of every single living being on this planet, that you have to have that biodiversity, that's the gene pool of the entire ecosystem. If as a result of your mining activities that gene pool or biodiversity hotspot is lost, then perhaps it will be a damage which will be incalculable, and that damage will always be felt by the mankind as well as the entire planet. Now, a petition came before the Supreme Court saying that please stop the mining activity. Why? Precautionary principle. Now, Supreme Court had to grapple with this. It asked certain questions. Is it your study that this mining activity will not have any effect on biodiversity? Nobody could say with certainty. They had to admit as a possibility that perhaps the biodiversity hotspot may get lost forever. Very well. What is the precaution that you can take? Again, a blank answer. If we go ahead with mining activity, what precaution do we take? There is not something that, I can protect that small environment or ecosystem where insects and centipedes and multipedes actually prosper and thrive. If there is mining, there has to be some kind of adverse impact on that. Then Supreme Court considered, supposing if today you don't mine that particular mineral, is that mineral going to get lost for the mankind? No. The mineral will be sitting in the bowels of the earth, whether you extract it today or maybe after 50 years. But in next 50 years, there is a possibility that perhaps we may have technological and scientific innovation and inventions where we may still be able to protect that biodiversity. And that sustainability will then demand that on one side you protect the ecosystem, and on the second side, your development activities, which a mining activity, can still go on. But so long as you are not able to come to that conclusion that yes, my mining can go on simultaneously with protecting that biodiversity hotspot, we will not allow you to go ahead with mining. And a thriving company and operations which were going on at Kudremukh had to be stopped as a result of the Supreme Court order. Isn't it a great manifestation of what is called precautionary principle? That you are taking that precaution. That very well, you may go ahead with mining, but your mining is definitely going to affect that, so therefore stop your mining. That is precautionary principle. Yes, ma'am.
Sir, I had a question similar in similar lines to the previous one. So recently there was a project that was approved at IIT Bombay. So it was regarding building a cycling track or walking track around the Powai Lake. So after about, like, it took a year of opposition, and then when we issued a petition, they they cancelled this initiative. So I wanted to ask the question, like, firstly they approved the initiative, and then after some more contemplation and when the construction work had already begun, they cancelled it later on. So how is it ensured that, and what measures are taken so that this problem does not take place in the first place? So what is the framework that is adopted while making such policy decisions? And
I'm not exactly aware as to the circumstances in which the decision was initially taken to have that cycle or jogging track, correct? And then maybe there was a lot of opposition, so therefore the decision was then thereafter put in cold storage, correct? That's what I gather, correct? Now, it could be that the initial decision itself was taken with perhaps without going into deeper into the issues in question, bestowing complete attention, or not considering what would be the adverse impact of that. Because there are certain, I see from I'm here put up at the guest house, one could see the lake, beautiful serene surroundings. So therefore, if you want to protect that environment, then perhaps the fauna, flora, which is living there are insects, there are sort of, the living beings there. If you have least possible human interaction, then perhaps that ecosystem will thrive and survive there. So the decision must have been taken on the basis that you can always have your cycle or jogging tracks at any place. Why choose for the first time, the very same idea which is close to the lake, correct? So therefore it must have been taken on that ground and suspended on that ground. Perhaps there was a litigation which was pending in High Court, I think. Yes. Thank you.
So I have two questions. I'm Dinesh. I'm officer from CRPF, and I'm doing my MTech here, sponsored. So my first question is, when there's a policy paralysis, especially like, as you're aware that currently we're having some state governments are implementing the old pension scheme, while some state governments are not. And this can lead to floodgates of court cases in the coming days. Can the courts take a suo moto stand and see this is something which we're not doing it right or something? Can it be done or not? And my second question, sir, there are many cases where the services, like where there are many organizations which have to approach the court for each and every small thing, right from the fixing of seniority till this thing. And my question is, there are many times when the same judgment is repeated in High Court, then it goes to the Supreme Court for ratification, SLP, and again on the same lines we have a court case running from the High Court once again, and a different interpretation is given by the High Court after ratification by the Supreme Court. In these cases, like how does the court view these things, or how does the service personnel get, how is he supposed to get justice in these cases?
See, in India, what we follow is governments at two levels, union government and state government. Now, if a scheme, say provident fund or pension, is implemented by central government, then it must be applied, it must be implemented throughout the length and breadth of the country. No dispute, no difficulty on that count. Whether you are in Dibrugarh, whether you are in Kochi, or whether you are in Jaisalmer, you will get the same benefit provided you are central government employee and you answer the description as to entitlement. Correct. The distinction or difference arises when there are multiple state governments who have different ideas. Now, say for instance, employees of state government of Maharashtra may have some kind of scheme for provident fund, whereas somebody from Haryana or Punjab may have a different idea for provident fund scheme. The genesis is as to who is funding the scheme. The funding is happening at the instance of the state government. Every state government is always grappling with the point and the idea as to conserve its resources to the extent possible and use its resources for the best possible ideas of development. There can be gaps between cup and the lip. Nobody says that the employee should not be given adequate provident fund. The only thing is what resources are available at the call of the state. So at times the state governments do take a different view. A particular government may be friendly towards the provident fund scheme. Another government may not be so friendly, but yet that government may be making tremendous amount of expenditure on public health issues. So it is ultimately for the government to make a decision and arrive at it, which are the priorities for the government. And if that be so, the courts are powerless to go into that. The courts can't say that if A state is giving this, B state must give that. That is not possible for the court. If central government is giving, then whether the person is located at Jaisalmer or Jabalpur, he must get the same benefits. No doubt about it. Because the origin is in the central government funding scheme. The central government as a funding authority can't have different ideas for the employees located at different places. There the source is one. Here the sources are different. So the moment the sources are different, the courts are powerless. Now the second question, I lost track of that. What
The
was
second
that?
question is that, so a lot of services are technically governed by the courts, where for each and every from seniority.
Oh yes,
till-
now I'll tell you what happens is, it is true that ultimately the seniority and all those related issues normally get covered by the decisions rendered by a court. But at times, even after the decision has attained finality at the level of the Supreme Court, certain challenges are still raised. Those challenges, if they are perfunctory, if they are superfluous and sort of useless challenges, they will certainly be buried at the level of the High Court itself. But at times the challenges do have something to be gone into. The courts are naturally there for the citizens. So if there is a point which has been made across, the courts can't then say that very well it has attained finality, so therefore hands closed, out you go. So therefore, that's exactly what we say, access to justice. See, every person, every citizen must have access to justice. And if he has a point to be sort of canvassed, which the courts consider adequate and good enough to be considered, the courts have to do that. Yes, next.
I teach at the Ashang Desai Center for Policy Studies.
Oh, great.
And we also have a course on Constitution Law and Public Policy, which is the institute elective. I have two simple questions, sir. This is my reading about the Indian Constitution. Now the codification process, centralization of law is taking place, whether it is labor codes or maybe the introduction of the GST. And you will rightly pointed out that the sources of the power, if they are different, the courts can get into court will have a problem. So how do you see the codification process and judicial interpretation of these codes, whether it is labor code or maybe like a GST? So how do you see that whether it will curtail the scope of a judicial review, or it will also expand the judicial review part?
See, again, you have answered the query yourself. For instance, GST. The earlier regime was sales tax, octroys, etc., which were state specific. Maharashtra may have a different set of rules, Karnataka may have different, Andhra may have different, Telangana may have different set of rules. The imposed 10% for something, 12% for something, it may also vary from state to state. Certain states may not even try to levy any tax on something. Like for instance, paddy will be exempt from in most of the states. What was that GST regime which was contemplated? It was one single unified regime across the entire nation. What was the source of that power? The source of that power was all states came together and then requested the union government or union legislature to enact something. Our constitution permits that. Minus that, every state was entitled as a matter of constitutional entity to come out with sales tax regime or octroi regime on its own. But they came together and said that in order to have consistency all through the nation, we will have what is called a common codified understanding. And that is how GST regime was actually thought of and implemented. GST regime again has two components, what is called the central government and the state government component. Something which is central government will go to the coffers of the central government, state government will go to the coffers of the state government. Idea is to have consistency so that one single item is not sold at different prices in throughout the different states. For instance, coconut oil will not be sold at X in say Kerala and X plus Y in Tamil Nadu. Otherwise what happens is X plus Y in Tamil Nadu, you have a traffic coming from X, Kerala to Tamil Nadu. So therefore that actually sort of unsettles everything. So therefore the source of power is actually in the common understanding. If that is the source of power, that's where the answer lies. But if the source of power is not in such understanding, like what he said, then the courts are powerless. Thank you.
So good afternoon, sir. I'm a student at Center for Policy Studies. And so I had a question in regards to, since we see the title as Administrative Law and Policy Framing, around which, so we sort of look at in the news or otherwise in our curriculum as well about policy influence. So, in the recent past, we have seen a lot of policies being framed by the judiciary. So how the judicial, centers of power, they are also influencing policies and also making some of the policies. For example, the policies that were made after the Vishaka judgment and the in Delhi for the pollution. So we know what happens and what we see in the media reports. But I wanted to know from you, from an inside perspective, when the people in the judicial, the judges or other stakeholders, when you are making policies in regards to any sort of that matter that comes to you, what are the thoughts that goes behind it? And sometimes we also see some unintended consequences of that. So I just wanted to know what is the thought process that goes behind it, and as you mentioned, policy making process in which sometimes courts are also involved. So if you could shed some light on those perspectives.
What you have done is, these are certain guidelines which are framed by the judicature itself, by the judiciary. I'll tell you the reason why it is. Please take your seat. Take for instance Vishaka. Vishaka, the very basis of that is that there are girls, women who at workplace are subjected to sexual harassment or kind of comments or advances. And it makes their life miserable, that's to say the least. And this was the common feature across the country, that ladies are now taking up to kind of occupations in the normal commercial establishments with a greater number. and naturally they are subjected to these harassments, so therefore there must be immediate kind of a set of rules where some protection is afforded to such girls and women. This was the basis. Now the basis lies in what? The basis lies in, so far as what we call Article 21 right to life of these girls and women employees. That they must have a system and an environment which is free of these kind of sexual harassment. Since the government was not coming out with any kind of clear-cut policy in the matter, the Supreme Court intervened for the first time. Now the possibilities are, supposing if Supreme Court had not intervened, there wouldn't have been set of guidelines which are in the form of Vishakha. So the Supreme Court would have simply thrown its arms in the air and said, sorry, we can't do anything. The policy has to be framed by the executive. So you, Miss so-and-so, go to the executive and sort of, ring the bell there. That would have been abdicating the functions. Because the cardinal function of the Supreme Court is that it is the guardian of rights, of fundamental rights of citizens. So therefore, Supreme Court came out with what is called Vishakha guidelines to say that there must be complete protection to such girls and women. In case there is any violation, then the violator must be brought to book. The violator must be departmentally proceeded against, and so shall be done to that person. I'll give you another example. After TMA Pi, where the Supreme Court held that right to education is a fundamental right and right to administer educational institution also flows from that, so institutions have that right. Naturally, the idea was, very well, if I have the right, I can impose any fee structure. So comes the judgment in Islamic, which was followed in Inamdar, saying that there shall be a fee committee, there shall be an admission committee in the state, which will go into the issue whether the fees which have been sort of structured by an educational institution is adequate or not. That is to say that we will look into the accounts, what is the income, what is the expenditure, and then the fees must be commensurate with that. It should not amount to profiteering from the institution or from the students. What was the statutory basis for that? None. Who invented it for the first time? The Supreme Court invented it for the first time. Why? Because if it had not done that, then the entire student community in the country would have been put to prejudice like anything. Some of the educational institutions were going to charge 25 lakhs something for, the courses in medicine. So everything had to be kept under check. Now it is with this idea that the Supreme Court then came out with guidelines which are called Islamic and Inamdar guidelines. Now most of the states thereafter have followed suit and have given the statutory status to these kind of guidelines, and now there are legislations. So therefore the initiative was by the Supreme Court. The legislature then stepped in and made it. Now the third and classic example is right to education. It was the Supreme Court which said in Mohini Jain and which was that case? In Mohini Jain and one judgment by Justice Jeevan Reddy, I just don't recollect the name. Which one? Unni Krishnan. That right to education is a fundamental right, though it was not something put by the Parliament in the third part of the Constitution. The Supreme Court said that right to life is a fundamental right, which contemplates that a person concerned must have the environment to develop his or her potential. How does one develop the potential minus the education? So therefore education must be taken as a concomitant, as the basic idea, And therefore, education itself, the basic education, which is primary education, must be taken to be your fundamental right. Now, that's the determination in Unnikrishnan and then in Mohini Jain. Who did that? It was the Supreme Court who did first. 10 years thereafter comes the amendment by the Parliament, which says now, right to education for children between 5 to 14 is a fundamental right. So at times what happens is that the responsive sort of, action coming from a quarter, perhaps from the judicature, is a faster one. And because it is at a faster and speedier rate, therefore the judiciary comes out with guidelines which are put in place. But the basic idea is that such guidelines shall be the governing guidelines till such time that the legislature intervenes. If the legislature has time and again actually intervened in the same direction as the Supreme Court, so therefore there is no friction or there is nothing. But at times there may be friction. Now, for instance, one of the judgments by the Supreme Court was on the lines that whether a person with criminal antecedents can contest election or not. So Supreme Court said, sorry, you cannot. But the legislature hasn't yet stepped in that direction. So therefore, there is not a consistent idea around the same time. I'm not saying there is a friction, but the way right to education was implemented by the Parliament, it's not getting so implemented so easily, correct? But there are areas and we have to learn to live with that. Why? Because it is through these frictions that we have the checks and balances. And through checks and balances, we ensure that these three ideas, executive, legislature, and judiciary, they keep the others in check. That's it. Whatever.
One last question.
Good afternoon, sir. Thank you for the informative talk and the guidelines which you have actually laid out for us also. My question is a bit on tech point. With the emergence of an, you can say, increase of AI and technology, and its tentacles spreading across the various sectors, including law and legislative. So do you see in 5 years or 10 years down the line that there might be a need to change the basic structure of constitution and the three the organizations under constitution because of the impact of AI which is happening? And because it's always that the policy and the organizations are always catching up with the tech, and it always has always has a curve where the technology is already peaked and the organizations are starting to understand what actually has happened. I mean, the classic case of social media and all. So how do you foresee it? And do we foresee that the laws of Isaac Asimov being inculcated in the basic doctrines of, let's say, constitution in near future?
See, technological innovations or anything which will certainly aid and assist you in a particular direction. But merely because there is technological innovation and inventions, that doesn't mean that we must change our ideas so far as basic structure is concerned. What is basic structure? Basic structure is stated to be certain principles which are so dear to the very existence of man. Like, for instance, right to life. Right to life today is part of our constitution. Supposing if tomorrow Parliament were to abrogate that right, delete that right from the fundamental rights chapter, does that mean that the citizen doesn't have right to life? So the basic structure, doctrine or idea was invented by the court to say that the amending power of the constitution cannot touch certain facets of the matter which are so dear for the existence of the mankind itself. So you may have power to amend constitution. For instance, what you may do is, today, say Maharashtra consists of, say, 50 odd districts. You may say tomorrow we carve out another state. Very well, do it. No difficulty about that. It doesn't impinge upon, it doesn't affect the existence of the citizens, whether they are in transferred state A or B, or restructured or reorganized state A or B. It makes no difference. So something which goes to the very root of the existence of a man, or something which goes to the very root of the existence of the system with which we are concerned. For instance, independence of judiciary is one facet of the basic structure. Can you say that, oh, I will sit in judgment over the judgments given by the Supreme Court and amend or delete some certain portions from the judgment? So you may have given a judgment which runs into 50 paragraphs. According to me, 5 paragraphs are immaterial, so I delete those paragraphs. Whether will it not be compromising the independence of judiciary? So therefore, certain principles which are completely dear are inviolable. Whether you have technological innovations or not is not the point. That innovation will certainly give you a different idea to look into the matter. But then every time you will test it, whether is it something which is very essential for the existence of the man or for the well-being of the society. And that's where the answer lies. Thank you so much. Thank you. I enjoyed it perhaps as much as you may have enjoyed having this interaction with me. Thank you so much. Thank you.
I take this opportunity to once again thank our Chief Guest, Justice Lalit, for sparing his valuable time and being with us today. Sir, we have not had enough of your vision and guidance, so we have arranged one more interaction at 4 o'clock for the students and faculty. This is again in VMCC itself. So those of you who want to come again and hear more of sir's valuable words, please do join us. Thank you very much, sir. Thank you, ma'am, too. Thank you.